This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author, and producer of these videos. Today, I'd like to talk about the fact that insurance is a necessity that is challenged by the law of unintended consequences. Neither the courts of the United States nor governmental agencies seem to be aware that in a modern capitalistic society, insurance is a necessity. No prudent person would take the risk of starting a business, buying a home, or driving a car without insurance. The risk of losing everything would be too great. By using insurance to spread the risk of loss, taking the risk to start a business, buy a home, or drive a car becomes possible. Insurance has existed since a group of Sumerian farmers more than 5,000 years ago scratched an agreement on a clay tablet that if one of their number lost his crop to storms, the others would pay part of their earnings to the one damaged. Over the eons, insurance has become more sophisticated, but the deal is essentially the same. An insurer, whether an individual or a corporate entity, takes contributions, premiums, from many and holds the money to pay those few who lose their property from some calamity, like fire. The agreement, a written contract to pay indemnity to another, in a case a certain problem, calamity, or damage occurs by accident, is called insurance. In modern industrial society, almost everyone is involved in or with the business of insurance. They insure against the risk of becoming ill, the risk of losing a car in an accident, the risk of business being lost due to a fire, becoming disabled, losing their life, losing a home due to flood or earthquake, or being sued for accidentally causing injury to another. They are insurers, insureds, or people dependent on one another. Now, unfortunately, the law of unintended consequences applies to just about everything in the world and, of course, applies to insurance contracts. Because insurance contracts can be simple or exceedingly complex, depending on the risks taken on by the insurer. I once read a policy many years ago that I can recite from memory. It said, "We insure against all risks of physical loss except war." That was it, the whole policy. It was as broad as anyone could buy. Today, no such policy could exist. Regardless, insurance is neither more nor less than a contract whose terms are agreed to by the parties to the contract. Over the last few centuries, almost every word and phrase used in insurance contracts have been interpreted and applied by one court or another. Ambiguity in contract language became certain. However, the average person saw the insurance contract as incomprehensible and impossible to understand. Courts, struggling to understand policies of insurance, added to the concern of legislatures. As said in Insurance Company of North America versus Electronic Purification Company, a 1967 decision of the California Supreme Court. Quote, the insurance company gave the insured coverage in relatively simple language, easily understood by the common man in the marketplace, but attempted to take away a portion of the same coverage in paragraphs and language which even a lawyer, be he from Philadelphia or Bungee, would find difficult to comprehend. This was also repeated in Hayes versus Pacific Indemnity, a 1970 decision of the California Court of Appeal. Ostensibly, to protect the public, to salve the concerns of jurists like the one quoted above, insurance regulators and legislatures decided to require that insurers write their policies in easy-to-read language. Because they were required to do so by law, the insurers changed the words in their contracts into language that people with a fourth-grade education could understand. Precise language, interpreted by hundreds of years of court decisions, was disposed of and replaced with imprecise, easy-to-read language. The law of unintended consequences came into play. Instead of protecting the consumer, the imprecise language resulted in thousands of lawsuits determined to impose penalties on insurers for attempting to enforce ambiguous, easy-to-read language. The lawsuits cost insurers and their insureds millions, if not billions of dollars to get court opinions that interpreted the language and reword their easy-to-read policies to comply with the court decisions. For more than 30 years, the unintended consequences of a law designed to avoid litigation has done exactly the opposite. The attempts by the regulators and courts to control insurers and protect consumers were made with the best of intentions, the same intentions that paved the road to hell. The judges and regulators found it necessary to protect the innocent against what they perceived to be the rich and powerful insurers. Unfortunately, the plain English statutes had the opposite effect. But of course, that fact, that easy-to-read policies cause more problems than they cure, the laws and regulations have not been changed. Because there is nothing worse, nothing more long-lived than a law provided to protect people that can never be changed, regardless of how bad it affects the public at large. In the 1950s, the California Supreme Court created a tort new to U.S. jurisprudence called the tort of bad faith. A tort is a civil wrong from which one person can receive damages from another for multiple injuries. The tort of bad faith was created because an insurer failed to treat an insured fairly, and the court felt that the traditional contract damages available were insufficient to properly compensate the insured. The court allowed the insured to receive, in addition to contract damages that the insured was entitled to receive under the contract that had been breached, had the insured treated the insured fairly, damages for emotional distress and punitive damages to punish the insurer for its wrongful acts were imposed. Insureds, lawyers for insureds, regulators and courts across the United States cheered the action of the California Supreme Court for providing a fair remedy to abused insureds. Most of the states adopted the created by the California Supreme Court, either by statute or court decision. After the creation of the tort of bad faith, if an insurer and insured disagreed on the application of the policy to the factual situation, damages were no longer limited to contract damages as in other commercial relationships. If the court found that the insurer was wrong, it could be required to pay both the contract amount and damages for emotional distress, pain, suffering, punishment damages, attorney's fees, damages for simply being made to work a little harder, and any other damages the insured and the court could conceive in order to deter other insurers from treating their insureds badly. The courts and legislatures adopted the tort of bad faith and hoped that the tort of bad faith could have a salutary effect on the insurance industry and force insurers to treat their insureds fairly. However, when claims for a $40 wrongfully denied claim resulted in a $5 million verdict, courts began to wonder, and certainly insurers began to wonder about the effect of this tort of bad faith. Juries unaware of the reason for and operation of insurance as an absolute necessity to doing business or living in a modern society, decided that insurers that did not pay claims were evil and that they wrote contracts so they never had to pay. The jurors were convinced it was appropriate to punish insurers severely, even when the insurer's conduct was correct and proper under the terms of its contract. The massive judgments were publicized, and many insurers decided fighting their insureds in court was too expensive, regardless of how correct their position was on the contract. They found it less expensive to pay than to fight, just as shop owners threatened by the mafia decided it was better to pay protection to the mob rather than fight. Most of the massive verdicts were reduced on appeal. The bad actors raised their premium and lost little business. Other insurers faced with the massive verdicts that were reported allowed fear to control reason and paid claims that were improper or fraudulent. The extra cost was passed on to all insurance consumers. The insurers who acted improperly were punished less than the honest insurers who were threatened with punitive damages without basis. The insurers who treated the insureds badly, in fact, profited, since they continued their wrongful acts and only were required to pay the few insureds that sued. Those that did not sue added to the wrongdoers' profit margins. Honest insurers paid frauds and claims they did not owe, and found they needed to raise the premium charges to cover the extra expenses. The increased premiums paid by insureds to cover the extra expense were a clear example of the effect of the law of unintended consequences. Rather than protecting insureds and making insurance more reliable and less expensive, the exact opposite occurred, and it is still occurring every day until there is some change in the law of the tort of bad faith, a fact that I have very little hope will ever occur. The law of unintended consequences struck the insurance industry and the insurance buying public. Rather than deter wrongful actions, the law of unintended consequences resulted in punishing the honest and correct insurers honoring the insurers who acted in bad faith with profit and allowed many frauds to succeed. This video was adapted from my book, The Law of Unintended Consequences and the Tort of Bad Faith, available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful to you or of interest, please refer it to your colleagues, and please subscribe to my Rumble channel, to my YouTube channel, and to my blog so that you can be advised of future videos. Thank you for your attention.